Case summary. Case citation. British Crane Hire Corporation Limited v. Ipswich Plant Hire Limited, 1975, QB 303 Court, Queen's Bench Division, England and Wales. Background facts. Claimant: British Crane Hire Corporation Limited. Defendant: Ipswich Plant Hire Limited. British Crane Hire Corporation Limited BCH East a crane to Ipswich Plant Hire Limited if under a hire purchase agreement. The crane suffered a mechanical failure during the hire period, leading to downtime and loss of earnings for BCH. IPH refused to pay for the downtime, arguing that BCH had provided a defective crane. Argument. Claimant's argument: BCH argued that IPH was liable for the downtime and loss of earnings because IPH had taken possession of the crane and therefore assumed responsibility for its operation and maintenance during the hire period. Defendant's argument: IPH argued that BCH had breached the implied terms of the hire purchase agreement by providing a defective crane. They contended that they were not liable for the downtime as it was caused by BA's failure to provide a crane in good working order. Final outcome and legal justification. The House of Lords ruled in favour of Esso Petroleum Company Limited, holding that customs duty was payable at the time the oil was sold, not at the time of importation. The court found that the Customs and Excise Act 1952 did not explicitly mandate payment at the time of importation, allowing for an interpretation that aligned with commercial practices and deferred payment agreements. Legal justification. Interpretation of statute. The court interpreted the Customs and Excise Act 1952, emphasizing that while it required payment of duty on importation, it did not expressly prohibit deferred payment arrangements or mandate payment at the time of importation. Commercial reality. The decision recognized the practical implications for businesses like Esso, which had legitimate reasons to manage cash flow and financial obligations based on commercial agreements with suppliers. Legislative intent. The court considered the purpose of the Customs and Excise Act 1952 and concluded that the timing of duty payment was not intended to be inflexible, but rather subject to practical and commercial considerations. Key concept implication. The case underscores the principle that once a hire takes possession of leased equipment, they assume responsibility for its operational risks, including downtime and consequential losses due to mechanical failure. It highlights the importance of implied terms in hire purchase agreements and clarifies the allocation of risk between parties in such agreements. Key learnings. Parties entering into hire purchase agreements must clearly define responsibilities and liabilities regarding the condition and use of leased equipment. The principle of assumption of risk applies once possession of the leased item is transferred, impacting liability for operational failures. Understanding implied terms and their implications in commercial contracts helps in managing risks and responsibilities effectively.